All right, you all. I'm going to call the Russell County Fiscal Court special called meeting to order October the 22nd at 10 o'clock. And we're here for the first reading of ordinance 2510 regarding solar farms / parks. So, Kevin?
I'm going to read the first part of and then I'm going to summarize, if you don't care, the balance of it. It's about a 14-page ordinance. You have it there in front of you. If there's questions or concerns or additions, subtractions between the first reading and the second reading, of course, we can do that upon your all's request. But Russell County Fiscal Court Ordinance number 2510, an ordinance of Russell County Fiscal Court establishing regulations for solar energy system installations in Russell County, Kentucky. Whereas the Russell County Fiscal Court, in pursuance of the powers and duties vested in it by the Commonwealth of Kentucky, addressing and establish minimum setback screenings and decommissioning requirements for solar energy systems installations, and whereas the Russell County Fiscal Court, upon the thorough review and deliberation, has determined that it's in the best interest to the public to implement a new ordinance to better address the contemporary needs and interests of both the county residents and solar energy systems as defined herein. And whereas pursuant to KRS 67.083, the Russell County Fiscal Court is granted the authority to undertake all necessary governmental actions for the welfare of the county, and specifically is endowed pursuant to KRS 67.03, subsection 3, subsection H, and KRS 67.083, subsection 3, subsection M, for the regulation of commerce for the protection and convenience of the public, and the power to protect and conserve the county's natural resources, including but not limited to soil and wildlife, to safeguard and the livelihoods and well-beings of its residents. Whereas the new ordinance is envisioned to embody more effective measures for protection and the conservation of the county's natural resources, thus fulfilling the mandate outlined in KRS 083, subsection 3, subsection H. Whereas KRS 278.718 became effective June 29, 2023. And further provides that an ordinance, permit, or license issued by a local government and enacted under the provisions of the Home Rule under KRS 67080, 67083, 67.850, 67922, 67A.060, 67C.101, and 82.082 shall have primacy over the provisions, including setback requirements set forth in KRS 278-700, 278-704, 278-706, 278-708. And any conflict between an order of the board and a local ordinance, permit, or license shall be resolved in favor of the local government's ordinance, permit, license. And whereas the Russell County Fiscal Court finds it necessary and appropriate to provide reasonable safeguards which mitigate potential nuisances such as soil erosion, water runoff, and erosions, large-scale loss of agricultural land, and the impacts to local flora and fauna, among others, created by large-scale ground-mounted solar energy systems as defined herein, in order to protect adjoining parties and public right-of-ways. And whereas the Russell County Fiscal Court desires to exercise its authority to this subsection, and now, therefore, be it ordained by the Fiscal Court of Russell County in the Commonwealth of Kentucky. The first section is basically definitions. Definitions that will identify the terms that are set forth in the application. So, pages 2, pages 3, pages 4, pages 5, down to number 2. All deal with definitions as you see them going forward in this ordinance. I call your attention to number 2, applicability. This ordinance and its requirements for licensure shall apply to the siting, construction, installation, enlargement, operation, maintenance, and decommissioning of large-scale SES, which is the solar energy systems facilities in all unincorporated areas of Russell County, Kentucky. And you'll notice down there, we have integrated SES, rooftop SES, small scale SES, and large scale SES. And those are identified by, as we go forward, I'll talk to you more about that. I'll call your attention to D. Large scale SES, where physical construction began prior to the effective date of the ordinance, shall provided. Physical construction is within 2 years of the effective date of this ordinance, and the SES footprint is not thereafter accumulated more than 5%. Number 3, license and renewal license. Prior to the commencement of the physical construction of the enlargement of the large-scale solar energy system, the responsible entity must obtain an energy license, solar energy license. Basically, you will be requiring them to apply for a license to be able to operate this system. And in that license, you can see in subsection A and subsection B requirements that they are required to provide this court, and I'll go through some of them. Of course, the name and owners of participating properties, the people that are involved in this, the street addresses, the tax map parcel numbers, so the court will be able to see exactly where this is, who it affects, and within 2,500 feet of the proposed SES. So basically, they're going to have to provide you the footprint, right? And then 2,500 feet outside of that, they will have to provide and identify any and all participating properties. Okay? So that gives you all an understanding of exactly what this looks like, what it means. They'll have to provide a written description of proposed property in conformance with the requirement of this ordinance. So they're going to have to provide this court with basically a list of things that, hey, we've done this and we've done this according to what this ordinance say. All right? So that will help you all as you look through it. Subsection B basically is just a requirement for them to provide 24 copies of the site plan. It just could provide you all with, in my opinion, all the information you need as far as who it affects within that area. They have to provide where the setback would be, what it looks like from this, and so most of the questions that you might have should already be answered with what's going to be in front of you, right? So, the questions of who it affects, where is it, how big is it, who does it touch, who doesn't it touch, those type of things. It's all going to be right there for you, and there'll be no question of that. They have to provide that, whoever they are. And I think one of the most important parts of this is of subsection 2, a decommissioning plan and a surety instrument, and we'll get to that here in a minute. We also will require, as a part of the application, a statement of the proposed SES conformance with the state approval, the state transmission siting. They're required to get approval by the state for that siting, so we'll be given all the state's information as well. I've also placed a fee entitlement for review and application. Now, let me talk a little bit about that. That will have to do with, you all by resolution following this will have to decide, if there's a fee that you want to attach to this. What you have to remember is, unless you change this, you all are the body that looks at it. And based upon what we're requiring in this, if you pass this, it's going to take some time for y'all to look at it, and it should. So, not only that, is that there could be additional costs that you all may not be thinking of right now, including, you all may want to hire engineers to get you may want to hire other people that could give you additional evidence that you need to make the best decision. So I'm not saying that you have to decide now what that fee is. I've just placed in there that you all will come back with a resolution on the amount of fee that's required to apply. And you can think more about that. Once the application is presented, you'll have 60 days to get a decision. You'll either approve it You'll approve it with conditions or modifications if you see things that are not in conformance with what you believe, or you can deny it, but you have to state a cause. Then 30 days following that, the county judge executive, by your all's order, will issue a license or a denial. Let's go on down to number 4. Number 4 are specific requirements, and I think that's kind of the meat of the ordinance. The specific requirements. The following standards shall apply to the siting, construction, installation, enlargement, operation, maintenance, and decommissioning of large-scale SES. A, setbacks. The SES footprint shall be set back no less than 2,000 feet from any non-participating property line and any right-of-way for a publicly maintained roadway or railway or rail line. Subsection B, perimeter access and screening. Access to the site must be controlled by a fence of at least 8 feet in height with vegetative landscape buffer provided between the fencing and the property line. The fence shall be equipped with screening to help shield the facilities and equipment from view. If you'll look at 1, 2, 3, and 4, it will describe to you what that screening looks like. It has to be 90% opacity where they can't see through it. But they also provide, you know, 8-foot tall fence, double row staggered, evertree greens, minimum of 5 feet in height, and just an additional buffer for the vegetation there. And you can see 2, 3, and 4 speak on how far they have to be from the fence, what they have to look like, and when the screening has to begin. I'll draw your attention to number 4. Screening shall be installed within 180 days of the start of the physical construction and shall be maintained until the discommissioning of the SES, meaning that all of these evergreen trees, all of this fencing, all of this screening, all has to be maintained for the duration of the term. So, lack of a better word, they have to stay, they can't leave it. Do you follow me? You know, they have to maintain it. If the trees die, or if the screen gets blown off, or the fence gets blown down, or whatever, it's their requirement to make sure that that's maintained. Okay. C, lighting. If there's lighting that is required relating to it, it shall be a minimum for safe operation, and lighting shall be designated to avoid light trespass. Basically, all the lights have to be pointed down and not out, so there's not a glare, around the surrounding areas. So they're required to do that as well. Call your attention to subsection D, decommissioning plan. The applicant shall be responsible for a decommissioning plan prepared by a registered professional engineer at the expense of the applicant and updated not less than 5 years, containing the anticipated life of the project, defined conditions of which decommissioning will be initiated, the estimated cost of decommissioning, including removal of the solar energy, system and related foundations, pads, underground collector lines, transmission lines, and then you can see 3, 4, and 5 is just, all of that is in addition to that. Long story short, on the decommissioning, they have to have a plan and they have to maintain a plan. And that plan has to be updated every 5 years. If you'll look at subsection D there's also required to be a surety, meaning they have to, the surety that is posted for this decommissioning project has to be in the amount of what it's going to cost to get rid of the stuff, if that's the case. And it's not one that starts in 2025 and nobody addresses it until 2050. Every 5 years, they have to provide this court with a new surety and a new decommissioning plan, because as you know, taking down things and putting up things costs more than it did 5 years ago. So that just ensures the county that and the residents that if the fears that you all were told of about running off or whatever that might be, there's going to be a surety that is going to step in and take care of whatever that cost is. Much like an insurance policy. I call your attention to subsection 5 on page 11. The applicant shall begin decommissioning no later than 12 months after the large-scale SES has ceased to generate electricity or thermal energy. All structures and facilities associated with the SES shall be removed within 6 months of beginning of decommissioning. So if it stops providing energy, then within 12 months, you have to have decommissioning begin, and it has to be finished within 6 months.
But now they're still gonna be bonded.
They're bond. Yeah, yes.
Now who's gonna keep, are we gonna keep the bond here?
Yes.
And then we're gonna keep the
Yes,
bond?
yes.
That way we know
Yes.
it's updated all the time.
And then, according to subsection 6, there's a license revocation. That's kind of the teeth, I guess, of it. If the applicant provides inaccurate or false information, if they fail to construct it in accordance with what the plan that you all were presented stated, then we have to give them a 90-day notification notice that we are suspending their license. That's when everything starts moving as far as, now they have 90 days to correct it to what it says, but if they don't correct it, of course, then you can suspend them and cause them to, again, all these other provisions to start happening, the decommissioning of it and things.
What if they sell this to a different company?
I'm glad you asked that. Number 7, license transfer. A change or transfer of the responsible entity's ownership as contained in a large-scale SES application shall require the issuance of an amended license. Shall be recorded in the Russell County Clerk's office no later than 30 days following the sale or transfer of the large SES facility. The responsible entity that has or is assuming ownership shall provide written notification to the County Judge Executive. And they shall provide as A, B, C, D, and E all this information of who they are and all those things. Now, they are also required to provide surety under them. It basically, if it's transferred or if it's sold, the new folks would have to do everything the old folks did.
Yep. All right. What if, like, two pieces of property comes together on the back side of it or down at the far end of it, instead of going down by the roadway where the two pieces of property comes together? Does that still have to have 2,000 foot in between them there?
Not according to this. It's just the outside boundary.
Yeah.
I'm not understanding what you're saying.
Where's
Not the
two
interior.
properties that's involved
Not the
together.
interior, the outer boundary.
Both of them are signed
The
up.
only one is 2,000 foot, but if there's two pieces of property, like over there on Miller Short Road.
If you have an application,
Yeah.
if you have an application with this piece of property and you have an application with this piece of
Yeah.
property, they're going to have to show 2,000 feet setback on both.
Just outside.
Even on the
On the
outside.
outside.
On the outside.
Oh, on the
outside.
outside. Not in between, not with the
I
two
think that's where it
properties.
says
But
participating.
For
and
all
not
participating, yes,
Yeah.
yes,
Okay.
yes.
All right.
All non-participating,
Okay,
Yeah.
that's what I wanted to be
Yeah.
sure of.
yep. Now, get to the back. All right. I also provided a severability clause, meaning that, in number 9, that if any particular subsection, for instance, if subsection 3 or subsection 5 or one of these particular provisions are met with court scrutiny, meaning that if they say we can't force this, or we can't force that, that particular section would be potentially unconstitutional and would have to be taken out, but the rest of the document would not be void. So, that just provides that if one or, and that's pretty common in ordinances anyway, is that if one part of it becomes an issue, then the rest of it's not thrown out, baby with the bathwater type of thing. I think I hope I've addressed most, if not all, the concerns you all had when you all were talking about it last time. And again, like I've said before, if there's additional things that you want me to consider, things added, taken away, those type of things, I will need to note those for the second reading, so you all will know exactly what you're voting on. Okay, I would just ask that if there is that that would be discussed, and we can make those changes before that date, because I'd like to provide a fresh copy of what you're agreeing to on that date, whenever that is.
And you need time to do it too.
Well, I don't need a terrible amount of time, but maybe a day or
You can
two.
get from the court over here in 2 minutes. You just did it.
Make it
So,
right across the street.
that is what I believe that is what you all requested. Anything different, you'll need to let me know.
It's been read.
Everybody satisfied?
I think it looks,
Huh?
Sounds good to me.
I think it's what we needed.
Need a motion to
Can I
adjourn?
ask a question?
We do questions?
Yeah. So you mentioned specific setback requirements in regards to non-participating properties and roadways, but I heard no mention of waterways.
It's not in here. I can add that if that's what the court wants.
That is what they initially asked.
Those
Okay.
opposed to this in the community would appreciate some consideration
Okay.
for waterways and what constitutes a waterway.
Okay, I can add, if that's what the court's requesting, I can add a definition section of waterway and add that in the
I think that's
setback.
what we talked on.
Okay, all right,
Initially, that was brought up.
We talked on the
Waterway.
waterways too.
okay.
One other question, should an entity choose to move forward with all of these things, what kind of recourse does the court have if they don't uphold this ordinance or these measures?
Well, they would suspend their license, and then if they did not fulfill the decommissioning plan and what was required, then the court would have to sue them.
Thank you.
One thing, since she said something about water, where I previously lived, they come in and started doing some, I call it industrial stuff. They was putting in solar panels, solar farms, so-called solar farms, some other things, and it ruined our wells because of damage from them drilling, digging, moving stuff. And so we had no drinking water because we was on solely well water. There needs to be something put in there on that.
Well, you would have a personal claim against the entity for that.
But it shouldn't be these people sitting here to have to fight it because we've allowed this company to come in.
Well, the decommissioning plan would include taking out all lines and those type of things.
So would they be liable for having city water run out to the places because you had no drinking water then?
Well, again, I can't provide an ordinance every particular
Right.
portion of what could possibly happen in a particular situation. The court has to take this document and do the best it can to address all those. But yes, I don't mean to say it, but yes, that would be, one house may be affected, the other house may not be. So that particular person, would they be liable? Of course, if they can prove that there's damage and that they caused it.
But they'd have to take action on their own.
Correct.
Well, what if said company went bankrupt? Then who's liable for cleaning?
Well, that's where the surety comes in.
Okay.
Now, who's liable regarding the individual, I can't answer that. That's a personal claim that the individual will have. I can't answer that. But as far as the decommissioning, the taking up of what has already went down, then that would be paid for by this surety.
Is this type of business considered commercial or industrial when they have to, because the profits off of the company is not coming to this county at all?
Well, what you have to remember is the state will also approve all of those things that they will have studies and looking into all of those things. There's a separate certification they have to get before they can even provide it to us.
Thank you.
And to be frank with you, I don't know what all theirs are.
I just want to tell you all, I appreciate each one of y'all. When all this stuff started happening, it's a big thing. And like he said, well water, that's all our little road is on, is well water. But I just wanted to thank you all for even listening to us. When we were having our little meetings, I just said, whatever happens, I want God to get the glory for it. Because this is to us a miracle, and He is the provider of all miracles. So I just want to appreciate you all and let you all know, because I want God to get the glory for it. And I said if you all went through with this and upheld what we wanted to have in an ordinance, that I would give Him credit for it. So I just wanted to thank you all.
Is it possible to put a maximum term limit on these projects?
This does not, no.
Could there be, 20 or 25-year maximum term?
I can't answer that. I mean, that's a question they have to answer. You can have anything until the court says you can't.
Well, if I'm asking, can this ordinance say that, that the project could be no more than 20 years or 25 years?
Can it? Yes.
Should the court choose to include that?
Correct.
Yeah. Can that be included, gentlemen? What's the time frame on this?
It doesn't have one.
It doesn't have one.
I have a couple more questions, if you could clarify. You mentioned a cumulative 5%. Can you go into detail about that?
The 5% of, let me get back to it. Basically, if you have one sitting already and their footprint increases more than 5%, then that would fall under this.
Okay, that makes sense. And you specifically mentioned, I'm not sure if this needs to be included or in addition to the solar portion, but also a major concern for us is the battery storage. So for clarity purposes, should that wording be included in this?
I don't think you can, because they all have to have batteries because there's no sun at night.
That's what I mean, but for clarity purposes, should that terminology be included in this document?
I think we took this was took from several different places.
I've reviewed, I guess, 10.
Okay.
I've reviewed 10, and I've never seen in any ordinance that provision.
Okay.
And again, I'm not saying it's not a good provision. I'm just saying what happens is sometimes, folks, is that when you restrict it, over-restricted, then you open this ordinance up to more litigation.
Scrutiny.
That's right.
I understand.
Now, I'm not saying that they wouldn't survive it or would survive it, and I'm glad that you asked that, because I do need I think I do need to speak on this. We have I could find one court in Caldwell County that has addressed these issues. Can this instrument be scrutinized and a court action? Of course it can be. There are conversations and people that believe that subsection or KRS 100, which talks about zoning and planning, require a county, before they do something like this, they have to have comprehensive zoning and planning. And that's an argument. What I could find was that in Caldwell County, a county without that, proceeded with a case, a ordinance just like this, and their circuit court upheld it, which I think, It's not been tested that I could find by the Court of Appeals or the Supreme Court. So what does that mean? Well, that means that it's open to scrutiny. And is there a court or a Court of Appeals or a Supreme Court that could say that under KRS 67, the county can do X, Y, and Z? That's what we're basing it on. Or does KRS 100 control, which means that the court could only do this if there was comprehensive zoning and planning in this community? I can't answer that. What I can answer is that there was a community in Caldwell County that had a similar issue, and they were told by that court that solar farms or solar systems that were already there would not fall under this ordinance, but new ones would.
I think the thing we got to look at is we're getting something we didn't have. And it's probably better than we anticipated when this all started, because the court, in my opinion, was thrown into this deal because of a public meeting you all had, and everybody came to get some relief from the court, and that, I guess this is the way the court is trying to help relieve it.
I will echo what she said. A huge thank you to all of you for your attention and your time. I know, Kevin, you've spent a lot of time diving into this, and it is much appreciated. I am not sure you all are actually aware that there are 5 projects in the initial stages in Russell County. Not just this one, not just Mount Olive. 3 other in every district are in the initial stages. So this doesn't just matter to us today in St. This is the entire county, and we appreciate you and your time.
You know, that was a concern of mine of you know, if we do this, are we just, you know, putting off the obvious, you know? But that court particularly talks about the difference between Chapter 100 and Chapter 67 and fell squarely on the county's right to be able to provide an ordinance in this fashion. Now, I can't promise you 2 or 3 years from now, folks, that there's not going to be a Supreme Court or a Court of Appeals that overturns this. I can't say that. But having said that, you know, that will be something for the court to do. But at this point in time, this is, I think, what you all requested.
Can I add something? From just my recollection on the other meeting, I thought someone had brought it up, and I thought we talked about it as far as putting something in the ordinance that would limit the total amount of acreage in Russell County that could be designated. And I don't know if that's legal or not, but I just remember it being discussed. Does anybody else recall that?
You're correct.
No.
We did speak about that, yes.
You're correct.
I mean,
I just.
you know, as I've said before, everything, it's not illegal, but I can't promise that at the end of the day.
Part of it that was in my notes is the only reason, because I remember saying this, so I don't.
I can't say. If the court wants to put in a limit on it, you're fine to do that. I don't know I don't know if that would stand scrutiny or not.
We gotta reach the part, even though we gotta honor your wishes as much as we can legally. We've also got these landowners that we gotta be careful and not overstep our bounds with them because it's their property.
We understand.
So we gotta keep that in mind, even though we're doing what we can. You know, I hope I'm making sense to you, you know.
Yep.
In
So-
regards to what Elena has just spoke about, and it being in other parts of the county, does this ordinance take care of every part that's going on, or just in the St. area?
No, every part but St.
It'd be countywide.
My answer to that is, I feel like if they have not proceeded to get certification from the state, and they've got already their conformance with the state, and they're all those particular things, I can't say that. I'll just be honest with you. I don't know. I don't have that answer. My thought is that that this would cover that as well. Now, again, that would be. I don't mean to sound this way, but it would be for a court to decide at what point is enough. You know, because I could see a solar company coming in and spending X amount of money, and they feeling like that, and if they've got a certification from the state that's enough. But again, I can't answer that.
The only certification currently is the Mount Olive that's filed with the Public Service.
That's the only one I know of.
And clarify that I think you said this ordinance, once it's in place, supersedes anything going beyond that.
It would, in my opinion.
That court ruled that the two that already had received final approval, right or wrong, they had to be grandfathered in,
Yeah.
that you couldn't change it.
A final approval meaning from the
From the
Public
state-
Service
from the-
Commission.
Yes, ma'am.
Yes, thank you.
Yeah.
Like on fire equipment, because the lithium batteries, from my understanding, I think you know more about them than probably anybody in here. On batteries, if lithium catches on fire, they can't hardly put them out. And does Russell County have the equipment to do that? To help with their safety, the firefighters' safety and all that as well?
We got a plant here that makes lithium batteries too. Across from Salem School, right? Superior.
Across the road.
I wasn't aware of that.
I can't answer.
I'm just curious on, I mean, I'll just.
Yeah, I think going back to what Kevin was saying earlier, we can keep getting in the weeds and getting it bigger and bigger, but then we're gonna have more scrutiny come. If we try to keep it where it's at, then we know these things have made it, so it's a lot farther than we were before. It may not be what everybody really wants, but it's a whole lot more than you had 2 weeks ago.
Agreed.
Can I just ask about oversight? Like, God forbid if this goes through, who is responsible for inspection as far as if they're completing everything to code? I mean, obviously, we don't want the solar company inspecting themselves. Is there a third
The
party?
answer would be this body.
It would be, okay. Okay.
I would think the public service.
Unless they delegate it to some other.
Like a third party.
Yes, ma'am.
Wasn't there a clause in there, though, that you said that there was something about that we could hire our own engineer?
Sure you
to
could, yeah, I mean,
inspect it, so
you
that
could,
would-
I mean, for that
An
matter,
engineer.
they could do that. Yes, they could hire X to,
But so could we.
yes.
Yes, okay.
We all know that solar energy is very inefficient, and how they're doing this right now, they're getting federal funding.
Yes.
So I think in a year and a half from now, when that federal funding stops, I think the solar farm will start.
I like your thinking.
Well,
It's easy to do on somebody else's money.
then you've heard the old
It's so
saying,
true.
nothing's forever
So true.
except God, so,
That's right.
you know.
Would there be restrictions that could be put on it, you know, without causing controversy, so much controversy, where it had to be completely US-owned company? Could not be sold to a foreign entity?
You can't even do that in the United States government right now. Look at how many foreign-owned companies have everything, down to even some of our national security stuff, so.
And is there any way to know what they are responsible for implementing? Like the checklist that you referred to? I'm just wondering, do
They
they
have
need
to-
to test our water?
They have to provide us with the state requirements, the
Okay.
certification,
Okay.
the conformance
So
with
they
all
will
of
do
those.
that at some point?
Yes, ma'am.
Yeah, they don't have to do anything
Actually-
without this in place.
Actually,
now.
it has to be provided to us at application.
At application?
Yes,
Okay,
ma'am.
great.
Now all they have to do is get it past the Public Service Commission. So,
That being stated, should the second reading be a little sooner than November the 10th?
why?
There's,
Because they're very close to
there's
fire.
legal requirements that,
That's what I'm asking.
there
What are
are
the
legal
requirements?
requirements on between, for fiscal courts.
Yes.
It's like no less than no less than 7, no more than 21. So, I mean, first of all, the second reading, I have to advertise.
Sure.
Well, the newspaper only gets published once a week.
Yes.
Okay, well, it's like, we couldn't have another meeting until probably like around the 10th would be about the time we would probably be able to have one. I don't know if it will be the week before, but I'm not sure. I'd have to look at the calendar to see
Would you
that.
be able to
Well,
would you be able to pass it at the next meeting?
At the
The
second
second reading
reading,
would be
will we
a vote.
vote?
This ordinance.
So Just,
If everybody's okay with the ordinance, we don't have to change it, yeah.
they are very close to filing for the Sano project. What's the deadline for tomorrow's paper?
Tomorrow.
It was last week. That's what it said. If I filed
You're looking at
something now, it would not go in until even next week.
The 30th.
And I couldn't do that because that's, let's say, well, what is today?
Yes,
Wednesday?
that would have been.
They can file it whenever they're coming up on, but that doesn't mean it gets approved either. So until they
If it
get.
gets filed with the Public Service Commission, they will approve it. They have no grounds to deny it until our ordinance is in place.
If I went back and looked at that correctly, there was people from this county that was on that Public Service Commission because it was happening in this county, and they had to vote to let it go through. The 2021.
For Mount Olive, yes.
Yes.
That's why we
Same.
can't refute Mount Olive.
Same would have to happen in this case, I would think.
Are the same people still on that board?
Not
They're
that-
appointed. They're appointed whenever they're requested.
Okay.
I'm just throwing that out there.
Yeah,
Is there a reason
I
we
think,
shouldn't go
I
ahead
don't,
and
I
have a
don't,
second?
I don't think it's a same day thing.
Say again.
I can't say for sure, but I don't believe it's a same day thing. I think that a siding board, a local siding board would have to be appointed and approved. That siding board would have to review those particular things. And then that siding board would then have to recommend it. So can it all happen in a day?
No.
Of course, anything can happen, but again, I can't speak on that. To be honest with you, I don't
Just
know.
trying to get this, we hope you will, of course, vote the way you seem to say you will. We hope and we believe that you will. We just want to make sure that gets done before they take their next steps. Make this a more lengthy process than it needs to be.
To your point, I'm looking at the calendar on my watch, the 10th would be the earliest that we could legally have that.
Okay, very good. Good to know. Thank you for checking that.
I need a motion to adjourn.
I make a motion we adjourn.
I'll second it.
All in favor? Aye.
Aye.
Any opposed? Same sign. We're adjourned.
Thank you, folks.
Thank you very much.